The Blanco Case, 1873. France, the year 1873. The nation was still rebuilding itself after political turmoil, reshaping its legal and administrative institutions. But one incident, seemingly small and personal, would forever alter the way modern states are held accountable. This is the story of the Blanco Case. The incident: in the city of Bordeaux, near a government-owned tobacco factory, a young girl was gravely injured. The cause was negligence. Workers employed by the state had failed to act responsibly, and the result was tragic. Her father, Monsieur Blanco, refused to stay silent. He demanded justice for his daughter and compensation for the harm she suffered. But his demand raised a question far bigger than his family's personal tragedy. Could the French state itself be brought before a court? The legal dilemma. Blanco's lawsuit was simple in form. The state was responsible, and therefore it should pay damages. But the state's lawyers pushed back. They argued, this is not a matter for the civil code. The civil code governed disputes between private citizens. But the state, they claimed, could not be treated like just another private individual. If the state could be sued in the same way as an ordinary person, its ability to govern would collapse. This legal clash turned a family's search for justice into a historic confrontation. Where exactly does the state stand in relation to the law? Tribunal de Conflits. The case reached the Tribunal de Conflits, a special court created to settle disputes about jurisdiction between ordinary civil courts and administrative courts. On February 8, 1873, the tribunal delivered its decision. The entire legal world was watching. The question was clear: should the state be judged under the same rules as everyone else, or under a different legal order? The judgment. The ruling became a cornerstone of French law. The tribunal declared, yes, the state can be held responsible for the actions of its agents. But this responsibility does not fall under the civil code. Instead, it belongs to a separate body of law, administrative law. And only administrative courts, not civil courts, would have the authority to decide such cases. This was groundbreaking. For the first time, the French legal system clearly stated, the state is not above the law, but it is judged by a different law. The impact. The Blanco case established two fundamental principles. 1. The state bears responsibility when public services cause harm. 2. That responsibility is governed by special legal rules, separate from those applying to private citizens. This single case laid the foundation of modern administrative law in France. It gave strength to the Conseil d'État, the supreme administrative court, and shaped legal systems across Europe. For Monsieur Blanco's daughter, the case meant her family's claim would be judged not in a civil court, but in an administrative one. But for history, it meant much more. A new balance had been struck between the power of the state and the rights of its citizens. Historical significance. Today, the Blanco case is taught in every French law school. It is cited as the birth of administrative law. Legal scholars across the world point to it as the moment when the state stopped being untouchable, when accountability became embedded into governance. The records of February 8, 1873, remain preserved, the tribunal's words echoing across time, setting a precedent that no government could ignore. The Blanco case began with a wounded child in Bordeaux, but it reshaped the very core of public law. It reminded the world that while the state holds power, it also carries responsibility. So let me ask you this. If your own government caused you harm through negligence, would you have a clear path to justice? Or, in your country, is the state still above the law?